This is Peter Laughlin, and I'd like to welcome you to today's presentation, Apply Now for Haitian-TPS. You've probably by now heard the great news that the Department of Homeland Security's Secretary Janet Napolitano has designated Haiti for Temporary Protected Status, or TPS as it's commonly called. The effective date to begin filing, as published in the Federal Register, is January 21st, 2010, and that filing period ends promptly in 180 days. So it's important for you to get going and not miss the filing deadline. In addition, I want to point out, for those of you who may be eligible Haitians who are already in some form of legal status and wish to apply for TPS, the filing period may potentially be less than 180 days. In fact, it may be 60 days. I encourage you to speak with an immigration attorney to determine your eligibility and to make sure that you don't miss the filing deadline. This presentation is brought to you by Goldman & Laughlin, the immigration-only law firm. Please visit our website at usimmigrationteam.com. Before going any further, I'd like to go through a brief disclaimer with you. The information provided today is offered for general education purposes only. You know that each case and its circumstances are unique, and it is therefore not possible to give specific advice in a presentation such as this one. Although the authors and presenters are immigration attorneys, the information provided in this presentation is not legal advice. If you do require legal advice, please make an appointment or contact an attorney of your choice. Let's get started. What is temporary protected status? Well, as the name indicates, it is a temporary form of immigration status. But it's important to note that it is a lawful status. TPS allows eligible Haitian nationals to live and to work in the United States for the designated term. Now that term is currently only for 18 months, but it may be extended. Another great feature is that TPS beneficiaries may also be eligible to apply for other immigration benefits or other immigration status, including adjustment of status, that is applying for a green card. However, I do wish to be clear and point out that it depends on whether or not the individual is otherwise eligible to adjust status or for another immigration benefit. And that could be dependent upon a number of factors, such as whether or not they entered the United States legally or if they entered without inspection. If you feel that you may be eligible for another immigration benefit in addition to TPS, I would recommend that you speak with a qualified immigration attorney. Now let's take a look at who is eligible for Haitian TPS. Most obviously, nationals of Haiti, or even persons who are without nationality, those who are typically known as stateless persons, who last habitually resided in Haiti. But primarily, the main category is nationals of Haiti. Not only that, they must have continuously resided in the United States since January 12, 2010. And they must be continuously present in the United States since the effective date of TPS designation. Also, I'd like to clear up another misconception. Haitian nationals who entered the United States illegally, that is, IWI, without inspection, or even overstays, and others, may still be eligible to apply for TPS registration. Please consult with your immigration attorney if you're in this category. Let's also take a brief look at who is not eligible for TPS. Well, obviously, by contrast, this means that nationals of Haiti who are not physically present and not residing in the United States since January 12, 2010 are not going to be eligible to apply for TPS. Now, this is sad, but what it means is that Haitian nationals who arrive in the United States after January 12, 2010, unfortunately, will not be eligible to apply for TPS. Also, nationals of Haiti who were convicted of any felony or 2 or more misdemeanors committed in the United States will generally not be eligible for TPS. In addition, as a starting point, there may be certain grounds of inadmissibility that may prevent one from being eligible for TPS. But hold on. Many of the grounds of inadmissibility can be waived, and they can be waived under a general standard of discretion, a lightened standard of discretion. If you feel that you are inadmissible or you have inadmissibility grounds, please do consult an attorney, because it may be possible to still apply for TPS. Let's discuss exactly how to apply for Haitian-TPS. You need to complete and file Form I-821, but it must be filed with the required supporting documents, and there is a $50 filing fee for USCIS. However, if you're eligible, you can apply for a fee waiver. In addition, you need to complete and file for an employment authorization document. That's Form I-765. And like other USCIS forms, there is a fee. It's $340 in this case. But again, if you are eligible, you can apply for a fee waiver. There is also an $80 biometrics fee required, unless you are under age 14. But like the other fees, you can apply for a fee waiver. Now, for those applicants who do not require a work authorization document, that would be rare, admittedly, but for those who do not require work authorization, you still must file I-765, but no fee is required. That is because the government uses that as a means of scheduling you for your biometrics appointment. Supporting documents for TPS. As I mentioned earlier, the I-821 not only must be completed and filed, but it has to be filed with certain supporting documents. You need to send in copies of documents evidencing your nationality, your Haitian nationality, such as a passport, birth certificate, in some cases secondary documents such as baptismal certificates, etc. You need to also submit documents evidencing your continuous presence and qualifying residence in the U.S. as of the effective designated dates. You are required to send 2 color passport photographs with your application. If you are filing for a fee waiver, you must file certain supporting documents as well. And for any applicants who happen to be inadmissible and are filing for a waiver, there's a separate waiver form. It's Form I-601, and is required to be filed with its own supporting documents and fees. Again, as I mentioned earlier, if you are filing for a waiver of inadmissibility, I highly recommend you speak with an immigration attorney. Frequently asked questions. Am I eligible for TPS if I am currently in immigration court in removal proceedings? The answer generally is yes. However, you will want to discuss with an immigration attorney if your case may be administratively closed. Another frequently asked question is, am I eligible for TPS if I've previously been deported or ordered removed? The answer here is most likely yes. However, this may depend on certain factors such as the actual cause of your removal order. In some cases, a waiver may be required. Again, where there is a waiver necessary, I advise you to consult with an attorney. Another common question that comes our way, and I partially covered it earlier, is what if I am unable to obtain the necessary supporting documents? Again, I want to strongly point out here that you may submit secondary records or any records, including affidavits, that would tend to support your eligibility. What to do next? The first thing you need to do is take action. Remember, the clock is ticking. There is a 180-day filing period, and it may be less for those who are already in some form of immigration status. Please visit our website to obtain forms and instructions at www.usimmigrationteam.com. And if you feel you do need attorney representation in your case, do not hesitate to call us in one of our local offices in Florida or nationwide at 888-274-6849.